I appreciate the efforts of All India Lawyers Union in conducting a seminar like this, in trying to create awareness not only in the legal fraternity but also amongst the citizens about the Constitution and what it says and what it is for. I'm also told that AILU conducts regular workshops for lawyers even in the districts, not only restricted to Hyderabad. I'm very happy to learn that an academic exercise amongst lawyers is being conducted by AILU. There is something which is lacking in the Indian legal profession, which is there in most of the developed countries, that is continuing legal education for lawyers. We do not update ourselves as legal professionals with the development of law. We come out of law colleges, stop reading books. We only thrive on practical experience, and most of us also experiment on people who come to us with their briefs. It is high time that the lawyer should realize that they should be well equipped, at least with the branch of law in which they are practicing. Having said this, I am asked to speak on this topic of revisiting the basic structure. As it's a mix of lawyers, citizens, and lawyers practicing not only in the High Court but in the civil courts, I will tell you the story of basic structure. That will be, I think, a better way for all of you to understand what this basic structure and the Constitution is all about. After a long struggle for independence, a time came in the 1930s where there was a talk of India becoming independent from the British yoke. The Government of India Act 1935 was passed, giving limited rights to people of India, elections being conducted in the provinces. It would be interesting to learn that it was only persons who were graduates and income tax payers who were permitted to vote for elections under the Government of India Act 1935. Then a Constituent Assembly was constituted. This was in the United India, where Pakistan was also a part of India. Elections were conducted, and in the elections about 350 people were elected to the Constituent Assembly. Most of them were from Congress, a few of them were from the Muslim League. Persons who came from the Muslim League wanted a separate Constituent Assembly for themselves. They said, let there not be one Constituent Assembly. And thereafter, as you know, there was partition, and the Independence of India Act was passed. There was an indirect election to the Constituent Assembly which had about 295 people. And this Constituent Assembly was the Provisional Parliament. As you all know, 14th night, it was the 15th of August 1947, when India became independent. But prior to that, in 1946 December, the Constituent Assembly started functioning. The Constituent Assembly appointed a drafting committee under the leadership of Dr. B.R. Ambedkar, who studied his law in UK, and Dr. B.N. Rao was given the task of drafting the Constitution and placing before the drafting committee. Dr. B.N. Rao visited various countries in the world, and then he borrowed provisions from the US Constitution, Irish Constitution, principles from UK, The Weimar Constitution, which is a German constitution, they even took provisions from Switzerland and then, well, Russia also. And there are some smaller known countries whose constitutions were read by B.N. Rao when he made recommendations as to how this constitution of India has to be. After about 3 years, almost 3 years, 2 years, 11 months of discussions, after the preparation of the constitution, the Constituent Assembly approved the constitution on 26th of November 1949. 26th of November each year is celebrated even now as the Constitution Day, because that is the date on which the Constitution was passed by the Constituent Assembly. Though it is not connected to the basic structure, the final speech that was made by Dr. Ambedkar on 26th of November 1949 is memorable. He said, "We are politically independent now. People can exercise their votes to elect people, their leaders. People are now governed by themselves. You do not have a foreign power governing. But the question remains as to whether we have really got independence." He said, as long as this country is divided on the basis of caste, religion and region, there is no independence. At that point of time, there were about 3,500 castes. He said that unless people rise above these vociferous tendencies, there will be no independence in India. And he said that a country that is going to be governed by ourselves is going to be a disaster, and there is no complaint that we can make against anybody else. At least earlier, we could complain against some foreign force ruling us. So, gentlemen, ladies and gentlemen, keep it in mind. All of us are educated. All of us at least project ourselves to be civilized. It is high time that we rise above all these considerations of caste, religion, and even the disparity in the society also has to be forgotten. All of us are equal. I'll speak more about it when I come to the preamble of the Constitution and the provisions of the Constitution. So the Constituent Assembly completed its job. It finalized the Constitution. And 26th of January 1950, you know, that is the Republic Day. On that day, the Constitution started working. Elections were conducted for the first time in this country in the year 1952. And Congress went to polls by saying that there is going to be a social revolution that will be brought by the party. They said that agrarian reforms would be there and justice would be done to a poor man in this country. On this promise, elections were conducted in 1952. Congress came to power. At that point of time, it was still the Constituent Assembly, which was the provisional parliament which was taking decisions. The Zamindari Abolition Act was passed. Zamindari Abolition Act was challenged in the high courts of Bihar, Madhya Pradesh and Uttar Pradesh. The Bihar High Court struck down the Zamindari Abolition Act. The Madhya Pradesh High Court and the Uttar Pradesh High Court, they upheld the Zamindari Abolition Act. Zamindari Abolition Act was struck down on the ground that it violated the fundamental right of property. Persons who had a right in property approached the High Court, and the High Court upheld their contentions that it was violating their fundamental rights. The Supreme Court had to take up the first case insofar as the Zamindari Abolition Act is concerned, and it was a judgment, if you can note down, Shankari Prasad. I'll just mention about 4 or 5 judgments. I'll not trouble you mentioning about too many judgments here. If it was a law college, I would have told you about more judgments on the Constitution. By this time, the Constituent Assembly, which was the provisional parliament, carried out the first amendment to the Constitution of India. By this amendment, there was an amendment that was made to Article 19 pertaining to freedom of speech, and our Constitution, which has about 395 articles and 8 schedules, which is the longest constitution in this world. There is no other constitution which has so many articles. A 9th schedule was added to the Constitution by the first amendment, and the 9th schedule said that any law made by the legislature or parliament, if it is put in the 9th schedule, it cannot be challenged in any court of law, and the court of law cannot set aside or declare it as unconstitutional on the grounds that it violates the fundamental rights. So the 9th schedule was introduced because Pandit Nehru felt that the courts were stepping more than the jurisdiction, more than whatever it is given to it, and when the parliament was interested in making agrarian reforms, the courts have been a stumbling block in carrying out the policies of the government. So the First Amendment was challenged before the Supreme Court. All these judgments of the 3 high courts which I mentioned, which dealt with the Zamindari Abolition Act, were brought to the Supreme Court. The arguments that were advanced in the Supreme Court were to the effect that the fundamental rights that were guaranteed to the citizen are supreme, and they cannot be tramped by the parliament by making amendments and saying that they are placed beyond judicial review, that is, courts cannot look into the laws that are made by the parliament. The 5 judges bench of the Supreme Court said that there is nothing wrong with Parliament exercising their power. They upheld the First Amendment and they dismissed the petitions that were filed in challenge to the First Amendment. Though not again connected to basic structure, the other amendment that was made by the First Amendment pertained to placing restrictions on the fundamental right to speech. There was a case that came from the province of Madras, that is the state of Tamil Nadu, where there was a communist-run newspaper which published some articles against the government, and the government said that they have committed sedition. So the newspaper took ground that there is a fundamental right of speech, and nobody can stop the press from writing what the truth is. So then the court had to interfere and then say that the act that was made by the government of Madras was in violation of 19. That made the parliament make an amendment to Article 19 by placing reasonable restrictions in Article 19. After the First Amendment was upheld, there was a rush for all the laws that were made by the legislatures to be placed in the 9th schedule, so that it is placed beyond the jurisdiction of the court. Nobody can challenge these laws. The numbers swell to about 250 laws that were made by the parliament, making these laws go out of the reach of the court's purview. Court cannot look into that law and say that this law is unconstitutional. There was an amendment that was made which is called the 17th Amendment, again placing several laws from Punjab and various other states, Rajasthan, etc., which was again challenged by people who have properties, saying that these laws that you are making would be affecting our rights of property, and our properties are being taken away by legislations. The Supreme Court again met, upheld the 9th Amendment, upheld the 17th Amendment, and they said that the Parliament has the power and there is nothing wrong with what is being done. The judgment of 5 judges was decided with a laser-thin majority of 3:2. There were 2 judges who dissented, and they said that the 17th Amendment might not be constitutional. 17th Amendment was revisited later at the behest of Chief Justice Subbarao, who constituted a 11-judge bench and decided whether The 17th Amendment is constitutional or not, and in a case called Golaknath. The point that was being argued and the Supreme Court was saying earlier was, there is a provision in the Constitution which is Article 13(2). Article 13(2) declares any law that is made in violation of the fundamental rights to be void. The argument that was advanced earlier was that even if you are making an amendment to the Constitution, that would be law falling under Article 13(2), and if fundamental rights are violated, then the court should interfere. Earlier, in Sajjan Kumar, the court said that an amendment made by the Constitution under Article 368 is not law that is mentioned in Article 13. That is a constituent power that is given to the Parliament. So Parliament has power to amend the Constitution. But the 11 judges bench, which was headed by Chief Justice Subbarao in Golaknath, held that an amendment made to the Constitution under Article 368 is also law in Article 13(2). And if any amendment that is made to the Constitution is violating fundamental rights that are given to the citizens of this country, then the court has the power to strike it down as unconstitutional. This is again a judgment of 6 judges being in the majority and 5 judges not accepting what the majority has said. By saying this, the 11 judges declared the earlier judgments as wrong, but it applied a principle of prospective overruling following some American judgments, saying that the judgment that is delivered by the court would be applicable only from that date, not setting aside whatever was done in the earlier judgments of the Supreme Court. Now comes the setting for Keshwananda Bharati. After Golaknath was decided, the government immediately swung into action, and they made 3 amendments to the Constitution, 24th, 25th and 29th amendments. The effect of these amendments that were made, 24th, 25th and 29th, is saying that the Parliament would have power to amend the Constitution in the manner in which it likes, and adding a proviso to Article 13(2), saying that it applies only to the fundamental rights in 13 and not to the amendment to the Constitution, and taking away judicial review. So with these amendments that came into force, a 13 bench had to be constituted because Golaknath was decided by 11 judges. And Keshwananda Bharati, which ultimately decided the basic structure doctrine, went on for about 60 days. Long hearings were conducted. It was decided during the course of hearings of Keshwananda Bharati that the correctness of the judgment of Golaknath is not being looked into by the court, but the interpretation of the word amend in Article 368 was the subject matter of discussion. So we'll have to understand the background of Article 368 and other relevant provisions of the Constitution before we proceed further, how we understand basic structure is all about. Our Constitution, as I said, contains about 395 articles. The most important chapters that we are concerned with here are Part 3 and Part 4 of the Constitution. Part 3 guarantees to all citizens of this country certain fundamental rights which are basic rights for existence of a human being. You have right to equality and equal protection of laws in Article 14. You have the fundamental freedoms in Article 19. You have a right to life in Article 21. And you have other rights which have been mentioned therein. I will not go into all those one by one. And the most important right that is given to a citizen in this country is Article 32. Article 32 is a right that is guaranteed to every citizen to approach the Supreme Court of India for issuance of a writ whenever there is a violation of a fundamental right, assuming somebody is being illegally arrested and his right to life is being affected. Somebody's freedom of movement is being trampled upon. Somebody's freedom of speech is being throttled. He can directly approach the Supreme Court and make a grievance about executive action and say that he has a fundamental right which has to be enforced by a court of law. Dr. B.R. Ambedkar, while the discussions in the Constituent Assembly were going on the fundamental rights, said that if he has to pick up one article out of these 395 articles, which is the most important article in the Constitution, he said it is Article 32, which is the heart and soul of the Constitution, because it gives the power of judicial review. It places checks and balances on executive power and even parliamentary legislation, which means, in simple terms, if there is a law that is made by Parliament or a legislature which affects the rights of people and the fundamental rights are being taken away, it is Article 32 and the Supreme Court which can interfere. You have a provision under Article 26 also which confers the same powers in the constitutional courts at the states, which are the high courts. They also exercise the same powers. These fundamental rights are very basic to a democracy. For a person to say that I'm a proud citizen of this country living in a democracy, he says that I have these rights which are not there in most of the countries. I'm a free man. I can do whatever I want. I can say whatever I want without any inhibition. Now comes part 4 of the Constitution, which speaks of directive principles of state policy. There is a duty that is cast on the state to ensure the welfare of the people in this chapter 4. Both chapter 4, the part 4, which is the directive principles of state policy, and the fundamental rights are like two wheels of the chariot. The state government has to see that the welfare of the people, including those downtrodden people, is taken care of by making laws. Laws that are made under the provisions of Part 4 of the Constitution is only for the purpose of improving the lot of the people, taking care of their health, nutrition, education. Everything is mentioned in Part 4 of the Constitution. The tussle between the Parliament and the court from the beginning has been, the Parliament says that I am making laws under Part 4 to benefit the people. Why should the court interfere on the ground that there is violation of fundamental rights? On the other hand, the theory in the protection of fundamental rights is that there is a basic right that is given to the society as such and individuals, and you could not be permitted to trample those rights. So this is the tussle which is going on. It's a healthy tussle actually. The question as to who gets supremacy is something which I will deal with a little later. So the balance between the directive principles and the fundamental rights has also come up for consideration in another case, which I'll just mention in another 2 or 3 minutes. We have this provision that permits the Parliament to amend the Constitution in 368. Why should there be an amendment to the Constitution is something which you might ask yourself. Thomas Jefferson, who is a great philosopher, who is the President of the United States, said that a generation is of 10 years. A generation changes every 10 years. Every generation has the right to decide what is good for themselves. We do not have a right to decide what would be good for people who are going to come into this world after 50 years. The societal changes would be there. Parameters would change. Living conditions would change. Still, the American Constitution has only 27 articles, and it has been there from 1797, except for the Bill of Rights that I mentioned. They say constitution is a living document. Why do they call it a living document? Because you make a constitution and then you apply the principles of the constitution to changing times. But would there be a need for amendment to the constitution? There would be. As I just said, that with changing times, changing policies, changing standards of life, there might be a need for the parliament to exercise this power of amendment. So Article 368 says that the parliament has the power to amend the constitution. That power is there. Now the entire theory of basic structure which I am going to speak of revolves around that power to be exercised by the parliament under Article 368 of the Constitution of India. And what did Keshavanand Bharati do? Without taking you too deep into the case, what Keshavanand Bharati decided was, there are judgments written, so many opinions were written, even by the majority there were about 5 opinions that were written. 7:6, 7 judges who formed the majority said, we can amend the constitution. What was decided in Golaknath, that Article 13 includes Parliament's power to amendment as ordinary law, is not correct. Parliament has the power to amend the constitution, there is no doubt about it. But you cannot amend the constitution to destroy the constitution. You cannot abrogate the constitution, which means that amendments can be made, but otherwise you cannot nullify the constitution. What does this abrogation of constitution mean? Which means that there are certain essential elements in the constitution which you call them basic features, basic structure, etc. Those cannot be touched. That's what has been decided by the majority. The other 6 judges said that where is this restriction you are reading into Article 368? If the word amend is used, that word amend also takes into its fold repeal, rescind, abrogate, destroy, demolish. Anything can be done by the parliament. Where is this parliament coming from? They are representatives of the people. So if the people feel that they want to demolish or destroy the constitution, let them do it. That's a minority opinion. Now, after this opinion was delivered by the 7 judges bench, the debate started as to what are these basic features. In the judgment itself, you will get an indication, the preamble that you are seeing is the basic feature. What is this preamble? This preamble contains the soul of the constitution. What does it say? That we are constituting ourselves to be a sovereign, socialist came in the 42nd Amendment, secular democratic republic. And what we guarantee to ourselves is justice, liberty, equality and fraternity. All these words are pregnant with meaning. They are not simple words. You just see justice, social, economic and political. Justice is not justice that is done in court. Justice, social, economic and political. Social justice, you must have heard. Political justice and economic justice. And when you are speaking of liberty, liberty of thought, expression, belief, faith and worship. Every religious minority should have a right to practice his own religion. Every person should have a right to speak out. Every person should have a right to develop himself into a complete individual. Liberty. Liberty is something which is very important for the existence of a human being, a meaningful existence. It speaks of liberty of thought, expression, belief, faith, worship. Equality. Equality is something which we have been talking of, which we are very proud of in this country, but I am not very sure whether there is equality in the society even today. All of you must be seeing that still there is a disparity in the treatment of individuals. That's the reason why initially I said that we will have to raise about all these. So it speaks of equality of status and opportunity. It also speaks of promoting them all. And the last one, which is the most important provision here, is fraternity. People don't speak about fraternity at all. What does fraternity say? Fraternity assuring the dignity of the individual and the unity and integrity of India. Fraternity is universal brotherhood. Fraternity is all of us thinking that all Indians are one. And then the unity and integrity of India. We only speak of fundamental rights, we don't speak of fundamental duties which is there in the Constitution. None of us speak of our duties. We only speak of our rights, we want to enforce our rights. That's for a debate on a later occasion if at all it arises. So this is the basic structure. The goal is the preamble, how this country should be governed. Apart from this, there are so many other basic structures which have been culled out by the court, which cannot be touched by the parliament. What are those? Supremacy of the constitution itself, which means that the constitution should not be done away with. Constitution is supreme. You have three wings. All of you know as law students and even citizens know that this country would be governed by three wings. You have the parliament that makes laws, you have the executive which carries out laws, you have the judiciary which decides as to whether the laws are correct or not. Apart from that, all disputes that are brought before the judiciary are decided by the court as to whether the executive is right or not. So there are three organs in this state. Judicial review, that is the right of the court to look into laws made, has been found to be a basic structure or a basic feature of the Constitution. Right to vote, because of this country being a democracy, that is a basic feature of the Constitution. Likewise, there are so many basic features about the country being secular, coming from the preamble again, and so many aspects which have been dealt with by the courts are basic. What do you mean by basic feature? Basic feature is where the Constitution cannot survive without these amendments, without these features, essential elements of the Constitution. The questions that were asked by the courts when they were dealing with this basic feature doctrine, which I will come to just a little later, is this, as to whether the Constitution can survive without these provisions or not. So what happened after the Keshwananda Bharati? Keshwananda Bharati's judgment came sometime in 1973. In the meanwhile, elections were conducted to the parliament in 1973, 1972. Indira Gandhi won from Uttar Pradesh, in a constituency by name Rai Bareli. She won over Raj Narayan in the elections. Raj Narayan challenged her election on the ground that there are corrupt practices that were committed by her. What are these corrupt practices? He said that she utilized her people working in the Prime Minister's office and the offices of the state of Uttar Pradesh and spent more money than was permitted in the election. The Allahabad High Court declared the election as void, set aside the election of Indira Gandhi, and she carried the matter in appeal before the Supreme Court. And it was vacation time. All of you know courts don't work in vacations, and the Supreme Court was having a vacation judge, and in those days only one judge was sitting in the vacation judge. Justice Krishna Iyer, whose name you must have heard, I was just told he is one of the founding organizers of this AILU. He was sitting in the vacation court, and Indira Gandhi asked for a stay, a complete stay of the judgment of the Allahabad High Court. He passed an order of a limited stay where he said that you can participate in the proceedings in the parliament, that you will not be permitted to vote. Actually, that was the starting point for everything. He said, we are not going to now give a complete stay of the judgment. We'll just permit you to participate in the parliament. That was the order that was passed. So what did the Prime Minister do, the then Prime Minister? She wanted to retaliate, and that's how there were two amendments that were brought into the Constitution. That was 38th Amendment and 39th Amendment of the Constitution. 38th Amendment gave power to the President to declare emergency in this country, and that emergency cannot be looked into by any courts. No court can interfere with an emergency. And 39th Amendment, the election to the posts of President, Prime Minister, Vice President and Speaker are put beyond the pale of judicial review. No court can look into the elections of these four persons. So they can do whatever they want and get elected, or nobody should challenge. 39th Amendment was again challenged in a very famous case, which is now Indira Nehru Gandhi versus Raj Narayan. To start with, the lawyer community was looking at the constitution of the court. They thought that this might not come out very well. By that time, emergency also has come. 4 judges who were in the minority in Keshwananda Bharati case were on the bench in Indira Nehru Gandhi in the case which was taking up the validity of 39th Amendment. What did 39th Amendment do, which I just told you? It declares that these people's election, Prime Minister's election, cannot be challenged anywhere. Number 2, no court has any power to go into these election matters of these 4 persons. On the ground that voting rights of individuals are a basic feature of the Constitution, 4:1, Justice Bhagavati was in the minority. The other 4 judges held that the 39th Amendment was unconstitutional, though the election appeal was allowed. So Indira Gandhi's election was upheld. We are not concerned with that, but the 39th Amendment was declared as unconstitutional by the court. What happened after the judgment of Indira Gandhi would be making a very interesting story for you all. This is something which most of you would not be knowing, because this is what was happening in the Supreme Court long time back. Chief Justice Ray was made a Chief Justice by Indira Gandhi by superseding senior judges, because they were in the majority in Keshwananda Bharati. Normally, Chief Justices in Supreme Court are made Chief Justices on the basis of seniority. Chief Justice Ray suddenly constituted a bench 2 days after the judgment of Indira Gandhi. 13 judges were sitting in court. Most of them didn't know why they were sitting there. They said that the judgment of Keshwananda Bharati is going to be reviewed. After 2 days of argument, Mr. Palkiwala made arguments for about 2 days, and then Chief Justice was asked by one judge sitting there, how was this bench constituted? What was the reason for the constitution of this bench? Who asked for the constitution of this bench? Then Chief Justice Ray asked Palkiwala, you asked for a review. So Palkiwala said, no, why would I ask for a review? I succeeded in the matter. Then he said, the state of Tamil Nadu filed a petition for review of the judgment of Keshwananda Bharati. And the Advocate General of Madras High Court, Tamil Nadu, who was there, he said that I didn't ask for a review. Then the Advocate General from West Bengal, he stood up and said, none of us filed an application for review. Then all of them went back. Next day morning, all the 13 judges assembled, and Chief Justice Ray said, we are not going to take up the matter. So an attempt that was made to review the basic structure doctrine ended like this. But the relentless struggle of the government in trying to get supremacy did not stop. The 42nd Amendment came, and the 42nd Amendment was brought by Indira Gandhi again with a number of articles, again taking away the power of the court, saying that the Parliament would have the right to amend the Constitution. Article 368 itself was amended by bringing in subclause 4 and 5. There are a number of articles that were issued. This was on the basis of a recommendation made by a committee called the Swaran Singh Committee. Indira Gandhi lost election after the emergency, but came back again in 1979. And this 42nd Amendment was again challenged, and Palkiwala had to come back from America to argue this 42nd Amendment. One thing which would be interesting for all of you to note is the names of persons which I just mentioned about Keshwananda Bharati. Keshwananda Bharati is a monk in Kerala. He has nothing to do with this case. He just lent his name, and Palkiwala argued that case. Likewise, now comes 1982 Minerva Mills. Minerva Mills had a case where the Sikh Industries Undertaking Act was challenged and it was lying somewhere. That was taken up, and 42nd Amendment was challenged, and Palkiwala argued that matter and succeeded in the court upholding his arguments that the power of amendment that is conferred on the Parliament is not limitless. And it was held in that judgment that the limited power of amendment itself is a basic structure. If you transgress this, and if you go on amending constitutions and changing the nature of the character of the constitution, that's not permitted. I was hearing a lecture of Justice Rohington Nariman, where he spoke for the 10th Palkiwala Memorial Lecture. Justice Rohington Nariman is an extraordinary jurist. I have seen judges and judges while practicing law and being a judge. But there are only a few people who can be called as legends, and Rohington Nariman is one. He was associated with this case, Minerva Mills. He just joined the bar and he was assisting Palkiwala in this case. He was speaking in that lecture. Palkiwala, while arguing, was, it seems, giving a few examples as to why the basic structure should be a feature for the constitutional amendments to be made by the Parliament. It seems he asked the court, if Parliament has the power to amend the constitution in the manner in which it likes, and if the Parliament decides that we will bring in some ruler like a Mughal emperor or somebody, and then say that we will hand over the country to that ruler, they can do it because they have the power to do it. Or they say that we will change the entire form of the government. We are following the Westminster form. Or they'll say, if the Parliament says Article 21, which protects the right to life of individuals, it says we are doing away with this Article 21. If it is permissible, then what would happen to the citizens of this country is the question that was posed. I am told that Minerva Mills case, which decided, has also decided, as I already said, that the balance between Part 3 and Part 4 of the Constitution, which are crucial to the running of this Constitution by themselves, are a basic structure of the Constitution. And thereafter, there were several several amendments that were made to the Constitution. I should mention that any law made by a legislation will be tested on grounds of judicial review, because the power that is exercised by the Parliament there is legislative power, it's not constituent power. Whenever there is an amendment to the Constitution, it is the constituent power of the Parliament. Whenever there is an amendment to the legislature, it is the legislative power of the Parliament. There were some amendments that were made. I think even this state also would be concerned with one amendment. There is a provision in the Constitution, Article 371D. Article 371D gave power to the President to establish a tribunal to decide service matters in the United State of Andhra Pradesh. There is a provision in that Article 371D, which is 371D5, which says the tribunal will decide a case, and thereafter if the government doesn't like it, it says that we can ignore it. So they can overrule the judgment of the tribunal. That was found to be violative of the basic structure, and Article 371D5 was declared as unconstitutional in the case of Samamurthy versus Union of India. There was another case which came about setting up of tribunals, administrative tribunals in Chandrakumar, where the judicial power of the High Court has been taken away, when that was declared to be unconstitutional by the Supreme Court. So basic structure is something which the court has been taking resort of to protect the judicial review and the right of the citizens to go to court and get justice. Something similar to what happened in our country when Indira Gandhi lost the election, she made laws, is happening in Israel now. For most of you who might be following the newspapers, you might be knowing that there is a turmoil in Israel. For some of you who might not know about it, I'll just tell you about the background. Israel has no written constitution. The parliament in Israel is called the Knesset. There are basic laws that are made in Israel, which is not the constitution, which govern the power that is given to the government to make laws. The Prime Minister now, Netanyahu, is on a slender majority. In the Knesset, he has a majority of 64:56. 56 are the opposition members. He stitched up a coalition and is continuing. There are criminal cases that are pending against him of corruption, etc., in a magistrate's court in Jerusalem. So he came out with this idea sometime in March of 2023 that the power of the Supreme Court has to be somehow or the other curtailed. So he thought that he will make an amendment to the basic laws, something like our constitution, whereby he would include a clause which is called an override clause, which means that the court will pass a judgment and the Knesset, which is a parliament, would sit and say, it's all right, we are overriding this. So the judgment is of no use at all. And he also wanted to interfere with the appointment of judges. In Israel, there is a judicial appointment commission which consists of 9 people. Unlike in India where judges, they have a collegium where they select judges, there is a judicial appointment commission. In that judicial appointment commission, 6 persons are either from the judges or from the fraternity of lawyers, which is the advocates. 3 are from the executive. So the majority is from the judiciary and the legal profession. So he wanted to reverse that. He wanted to have more people on the executive so that the selection of judges would be in the hands of the executive, and the executive can have its own persons as judges who would not rule anything against the government. It so happened in Israel that the awareness of people was carried out by certain democratic institutions, and there was an agitation. The citizens of Israel started taking to the roads. Every Wednesday, there used to be some sort of a demonstration where people were saying that citizens' rights have to be protected. These demonstrations continued for about 36 weeks. It was almost reaching a crescendo at some point of time. About 3-4 months back, I got a call from Israeli Democratic Institute, which has been there from 1930. They wanted me to go and then speak about democracy and how the constitution works in India and what is this basic structure principle. So I went to Jerusalem. Before the conference took place the next day morning, in the evening, I was told by Professor Yaniv Rosnai, he is a person who did his research on basic structure and has written a book on basic structure. He said, Justice Rao, let us go and then visit and then see the demonstrations happening near the President's house. We just walked up, and there were about 30,000-40,000 people of all ages. They were just having some placards in their hand that there should be rights of the citizens which should be protected, and they were walking. Professor Yaniv asked me, you pick up anybody from this group who are demonstrating, ask them why they are demonstrating. Ask them what the problem is, why are they on the streets now. All of them are very well educated people, they have their own lives to lead. So I just picked up an elderly couple of about 60 years. I just stopped them and asked them, what's the problem? Why is this demonstration going on? They told me, 5 minutes they explained to me, what is this override clause? How is it affecting the rights of citizens? If the power of judicial review of court is taken away, what would happen in a democracy? So it would become a dictatorship. Then I asked them, what do you do? One of them said that he's a carpenter. And his wife said that, I don't do anything, I'm a housewife. This is the level of awareness and consciousness of the people in Israel. After the conference was over, midnight I got a call saying that, Justice Rao, you have to leave early in the morning because tomorrow there is going to be a complete Bandh of Israel. I reached the airport, all the flights were stopped. With great difficulty by evening I somehow or the other came out. But what made me think was this, which is a question which I want to pose to you. How many of you would think that such a thing would happen in this country? If at all, there is some law that is made now saying that there can be no case against Prime Minister Modi. Another law that is made saying that Supreme Court's powers are taken away or the High Court's powers are taken away. Anything that is done by Parliament or Executive would be supreme. Would we take to the streets? I don't see our reacting like this. All of us are very well educated. All of us know that we have rights to protect. All of us know the importance of the Constitution. But still, we do not question because we haven't learned to question. I think this is something which we should imbibe in ourselves. Whenever there is an act which is oppressive, we should be the first to raise our hand, which we never do. So, the lesson that we learn from Israel is that all of us not only should react, but also create awareness among the people about the importance of the Constitution, importance of basic structure. I'll also tell you what happened after that. There were discussions. In Israel, the defense minister was against these amendments. In Israel, there is a problem between the Jews and the Arabs. There's always a problem in the Gaza Strip. It continues, and then there is some sort of a internal strife which is going on. The Attorney General of Israel, unlike our Attorney General here, is an independent person. The Attorney General of Israel said that this legislation is not correct. She didn't support the government. Like a government leader, can the government leader say government is wrong? She said no. What is being done is wrong. The defense minister said no. The president said no. President is a nominal president there. But still, the prime minister wanted to proceed. In spite of such demonstrations, he made law. The Knesset made law in June. The law, though has been scaled down, is to the effect now that though the Supreme Court has power of judicial review over parliamentary legislations, it cannot set aside any legislation on the ground that it is unreasonable. So, which means that you are clipping the wings. It says that your powers are restricted. The second one is relating to exactly what Prime Minister Indira Gandhi did then. Netanyahu has brought out a law by saying that the Knesset would decide as to whether a person should be the Prime Minister or not, in spite of some cases being there against him, because the Attorney General was saying that you should not be the Prime Minister because there is a criminal case against you. So he brought out that law also to ensure that he will not be sent out, trying to protect himself. These two laws were challenged in the High Court of Justice, as they say in Israel, which is the Supreme Court. The Supreme Court there has 15 judges. And these 15 judges, in the normal course of business, they sit in a division of 3 judges each. But to hear these two cases, they sat all of them together, en blanc is what we say. So 15 judges sat and then they heard arguments. September 12th, arguments were heard by the 15 judges in respect of this unreasonable clause. And last Thursday, that is the 28th of September, arguments were heard by a 11 judges bench headed by the Chief Justice in respect of the law that relates to protection of the Prime Minister. The questions that were put by the judges make interesting reading. So the judges were trying to ask the advocate who was appointed by the Prime Minister, because the Attorney General was not supporting the government, there was a private lawyer defending the government. So the questions that they were asking the lawyer appearing for the government were exactly the same questions which were put to the Attorney General of India when Keshwananda Bharati was being heard, or Minerva Mills was being heard, or Vaman Rao was being heard, as to what would happen to the citizens. You do not want somebody or some organ to become so powerful where the balance would not be there. We do not have separation of powers in this country. Separation of powers is only spoken of in judgments. You have three wings, each of them trying to take over the other. There is the parliament wants to make laws and then say that court should not interfere. And court would be saying that this parliamentary legislation is not correct. Parliament doesn't like it. Executive decisions are interfered with by the court day in and out. Executive doesn't like it. Passes an order, court says stay. So they would say that how is it that we can run the government? I'll tell you an interesting incident without mentioning names. Before I became a judge, I was a law officer in both the governments, Congress and BJP. I was an additional Solicitor General. So one law minister who was a seasoned lawyer earlier, very seasoned lawyer, one of the stalwarts practicing now, he was a law minister, and then the right of privacy case was going on. The Aadhaar card case just started. I was asked to defend the government of India. I went and told him the judges are putting such inconvenient questions. What do we do? For a marriage registration, it seems Aadhaar card is being required to be shown in Bombay. This is about 10 years back, not now. All of you got used to all these Aadhaar cards now. Those days, people were agitated as to why Aadhaar for everything. So I was told by the law minister that what do the judges think of themselves? We are running the government. We know the difficulties of people. We are all elected by the people. Why should they start interfering with this? The same person who was a lawyer earlier, a lawyer now. So when you are there in the parliament, your perspective changes. When you are in the executive, you think otherwise. So when parliament makes legislations, what it does is, it definitely carries out the wishes of the people. In the United States of America, there is a principle called a counter-majoritarian difficulty. Alexander Hamilton wrote a book, The Least Dangerous Branch. He said that the least dangerous branch in the government is the judiciary, because it neither has the purse nor the sword. Purse means it doesn't have the money. For the money to run courts, judiciary has to depend upon the executive. Ultimately, money is sent by the government for the High Court to run here, and the salaries are paid by the government. It doesn't have fund on its own. It doesn't have the sword also. Which means it passes an order, it passes a judgment which has to be implemented by again the executive. If the executive says I am not going to implement, again contempt powers etc. are there, but the judiciary doesn't have policemen, or judiciary doesn't have army for implementation of its orders. That's the reason why Alexander Hamilton said that this is the least dangerous branch. But when the US Supreme Court started interfering in legislations from 1905 to 1930, in most of the legislations on grounds of judicial review in the due process clause, which we don't have in India, they have started some sort of a philosophy which is called this counter-majoritarian difficulty. Questions started asking, who are you? The questions to the judges is, you are not elected. You are just sitting here and then saying that the parliament is wrong. Parliament is represented, they are representing people. They know what they want. So you do not have the right to say Parliament is wrong. You should defer to the wishes of the Parliament. 9 judges sitting in the US Supreme Court, they can't say that the legislation is wrong on due process. So this is one theory there. Now, I come to the final portion of revisiting the basic features. All these years, people were not talking about basic structure. All of a sudden, there is a debate on basic structure for the past 1 year. How has it all this started? We have some constitutional functionaries, I am again not going to refer to them, who started saying Keshavanand Bharati is wrong. So some judges started defending, some legal professionals also started defending, saying, oh, what is wrong with this? So everything is all right for these years, 73 onwards till 2023, everything was going on smoothly, government was also happy. So suddenly why this debate? The debate is because, again, the Parliament wants to make some laws, take them out of the reach of the court. Again, revisit the debate that was there about 50 years back, because it's 50 years after Keshavanand Bharati was decided by the Supreme Court. The problem in this country, as I see, constitutional functionaries do not stay within their limitations. We have speakers, after becoming speakers, towing the line of political parties. Day in and out, you might be seeing the speakers speaking on behalf of the ruling party, making comments in favor of the ruling party. There are no more independent. You have governors who have also been exceeding their briefs. I'll tell you about one case which I decided. There is the Rajiv Gandhi assassination case. A bail filed by a person by name Perarivalan came before me. He has been in jail for 39 years and he has got 7 degrees when he was in jail. The state of Tamil Nadu wanted to release him by exercising power that is conferred on them under Article 162 of the Constitution. The governor doesn't want to decide. The position of a governor in the Constitution is he is head of the executive of the state. He doesn't have an independent view except for when he exercises powers as a chancellor of a university and other functions like that. 2 years he sat on the file. Perarivalan continued to be in jail. When the writ petition came up before me, I gave a long rope to the union government. The state of Tamil Nadu was saying that we have done our bit, but the governor is not passing an order. So I called the law officer and then told the Solicitor General, you better tell the governor to pass an order, otherwise we are going to give a direction. The problem of giving a direction to the governor is governor has an immunity, president and governor. But still, we have ways and means of getting an order passed and then directing the office of the governor through the state government to act. That's a judgment of the Supreme Court in Rameshwar Prasad. So with great difficulty, we made the governor take a decision. And what is the decision that he took? After 2 years, the decision taken by the governor is that I will refer this matter to the Union of India. The Union of India will now decide. A decision taken by the state government for which either he has to give approval, not either, he has to give approval. He says, now I'll send it to the Union of India, let them. It's very easy. So if I have to take a decision, I can escape by saying, this is called passing the buck. So the file goes to the next table. I need not take a decision. And we had to take an extraordinary step. Normal course, we won't do it. But under Article 142, a power that is given only to the Supreme Court of India under the Constitution to pass orders to do complete justice, I thought it is high time that he comes out. So that's the reason why we released Perarivalan, and after Perarivalan release, the other accused also have come out. Law is the same for everybody. Whether you are the Chief Minister, whether you are the Prime Minister, and whether you are a person who are a laborer, when you are talking about that equality, which means equal protection of laws, applicable of laws to a person. Merely because you are accused of a grave offense, it doesn't mean that you are not going to get protection of laws. So speaking of liberty, liberty is applicable to every person. So there cannot be any discrimination, at least by the courts. So when the court is exercising powers like this, you look at such instances where constitutional functionaries also go overboard. I would not shudder to say that even people from my tribe who are retired judges, they also overshoot. They also start getting into a debate. They also start criticizing their own people. All these things are not desirable. One thing that all of us have to remember, especially from the legal profession, is we should protect our judges. There is nobody to protect them. They cannot even speak out. At the same time, if at all there is an erring judge, you should be the first one to raise your voice and bring it to the notice of whoever the authority is. I am not saying you should suffer anybody. You must be facing a number of persons who are unreasonable. Unreasonableness is not a ground to say that he has been misbehaving. But if at all he is crossing a line, definitely you should take it to the notice of whoever is in charge. The level of debate as it has come down in the political sphere is coming down in public life as well. So when you have people who just want to raise some issue by holding constitutional positions, that's how the situation which has arisen now about, is it required that we should revisit the basic structure? For what reason? What has happened to this country? Is there anything wrong that has happened suddenly where you say that Keshwanand Bharati is wrong? The Chief Justice of India recently said Keshwanand Bharati is a North Star of Indian Constitution. I agree with him. We are what we are today, still enjoying this democracy only because the parliament is in check, only because the executive power is in check. And who is doing it? It is the court. I am not saying court is supreme. There is no organ which is supreme in this country. It is only the constitution which is supreme. So this war cry of politicians saying parliamentary supremacy, according to me, definitely is not correct. All of us have a duty to imbibe the constitution, to protect the rights of citizens of this country. As legal professionals, we have an extra duty, and I am sure that AALU will continue the endeavors which it is doing now by having seminars like this. You're going to have Justice Muralidhar, who is an extraordinary judge, who is going to address you in the afternoon. Justice Rajni is going to speak to you in the afternoon. I'm sure that all of you would enjoy listening to them. I'm also sure that I've shared my ideas and some of them are interesting also to you. And I hope I have been able to communicate myself well. Thank you so much for the patient hearing.